cases and rebuttal of defensive theory cases and all of that, and I haven't found a single one that would justify the admission of the extraneous conduct that the state is seeking to admit. It's the force of that precedent that's going to cause this court to deny a motion to admit extraneous offenses at this point. However, I consider this to be the nature of motion limiting. If at any time from this point forward until the end of this case, if you feel like the board has otherwise been able to Mr. Snipes, please approach the bench. I'll consider that. These are fluid decisions, and I understand that. The parties have indicated to the court, really, Mr. Snipes has indicated that based on my ruling, you're going to ask the jurors to be here. Is that right? Yes, sir. And it's 8:30. The record should reflect the jurors are not here, but in the interest of time and trying to utilize this court's time efficiently, I've had some conversations with Mr. Gill. First of all, Mr. Gill, based on Mr. Snipes' representation to the court that he's going to rest, do you have any motions that you wish to make at this time on the record?
Yes, Judge, I do. If we could consider that the motions having been made at the time they've actually rested, I don't mind doing it now.
Thank you for that. I appreciate that. And I will.
But in each of these three cases, the defense at this time would move for a motion for instructed verdict, acquittal in each of the three cases, in that the state of Texas has wholly failed to bring forth evidence on each and every element of each of these three indictments. And just singling out the fact in the two aggravated assault by peace officer indictments, the testimony in both of those cases was that the people that were allegedly assaulted by Mr. Oliver did not know what was going on, did not know Mr. Oliver was a police officer, did not know that there was a weapon being used, and therefore they were not threatened with any imminent harm or threatened with any deadly weapon at that time. And in addition to a general motion for instructed verdict, we also make a motion for instructed verdict on that ground.
Your motion for instructed verdict in all three cases is denied. Is there anything else that we need to put on the record? Mr. Gill has requested the court to go ex parte regarding the matters they wish to take up outside the presence of everybody. That's in the nature of what they intend to do this morning. I won't make any rulings, Mr. Snipes, but I'll do that here in just a moment. Is there anything else that we can take up outside the presence of the jury now in anticipation of your case?
Yes, Your Honor, there is.
Okay.
And if this motion could also be I need to hold on to that motion. It's very brief, though.
Okay. So,
but we are ready to, for the ex parte hearing, if you'd like to take that up now.
I can do that. And you intend on calling any expert witnesses?
We do, Judge.
Okay. When would you like to do those hearings?
Well, we don't need a hearing.
We'll request a hearing.
Okay.
Very good.
That's up to you, Judge.
All right. I'll tell you what.
I'll tell you what. If we can go ahead and consider my motions having been made. No, I can't make a motion. I'm sorry. Go ahead.
Well, do you want to do it right now, or do you want to?
I need to do it after the state rests. After the state formally rests.
Okay.
It's brief.
Okay. We can do that. Remind you.
Yes, sir.
And do you want to do the in-chambers matter?
We can do that right now, Judge.
Okay. Let's do that very quickly.
Yes, sir. Just one thing for the record. There's a housekeeping thing with regard to some of the state's exhibits. I wanted the record to be clear. There were a couple of state's exhibits that were conditionally admitted yesterday, and I don't think that I re-offered them for all purposes. So just want to do that now.
Go ahead, please.
264, statement number 264 was the rank and file report by Heather Francis. The state would offer that for all purposes at this time. There was testimony by the medical examiner yesterday with regard to collection of evidence, specifically hair. They would accept the further testing of scripts as well as 285, which are the test fired casings from Heather Francis as well, 223 casings.
I'm sorry,
223 casings that were fired from the state's 229 rifle. We would offer that for all purposes. And I made a mistake. I asked the court to admit for all purposes 246 which was the GSR analysis report by Kara Crosswise. That should have been for record purposes only because the court admitted that sustained an objection with regard to confrontation of the witness. It should have been stage 247, which was Dr. Cashman's GSR report, so we would offer that for all purposes.
247 for all purposes.
Yes, sir.
Crossways report violated verse, right? And so 246 is that number?
246 should be just for record purposes only.
Okay. It's only for record purposes.
Yes.
264 is admitted for all purposes, subject to the objections that you made yesterday.
Thank you.
And 285 is also admitted for all purposes, subject to the objections that you made yesterday. Is there anything else, Mr. Lewis?
And 247, Judge.
247 is admitted for all purposes. That's Dr. Castro's report.
Yes, sir.
Remember Dr. Castro?
I do.
And that's admitted for all purposes. 246 for record purposes.
Thank you, Your Honor.
Our objections noted and overruled that exhibit also.
They are.
Thank you.
Okay, this court's in brief recess. See the lawyers, Mr. Wood, if you could.
Okay, I'm going to turn this on. I'm ready, Judge.
All right, very good. Let's go on the record. This is the State versus Roy Oliver. Lawyers are present. Mr. Oliver is present. The State is present. The defense, given the procedural posture of the case, has indicated that they wish to call an expert witness in their case in chief. We have a witness ostensibly here as an expert. If you could please raise your right hand. You swear the testimony that you're going to give today will be the truth? I do. Please have a seat. We'll be responding to questions from Mr. Lane and perhaps also Mr. Snipes directly in front of you. Thank you, Your Honor. Go ahead, Mr. Lane.
Thank you, Judge. Captain, sit down and pull that microphone up so everybody can hear you.
Okay, how's that?
Good, good. Would you introduce yourself to the court?
My name's J. Oliver Coons.
And how do you spell your last name?
C-O-O-N-S.
You want to be called Miss Dr. Oliver Coons, or do you want to be called Captain?
Well, just not late for lunch. Captain's fine.
Could you tell the judge where you are currently employed?
I'm currently a captain with the Harris County Sheriff's Office in Houston, Texas.
And in that job, what do you do?
I'm the commander of the District 1 Patrol Office.
And could you give us briefly your TCO certifications?
Yes, I have a basic, intermediate, and advanced and master's TCO certificates. I have an instructor certificate.
Is that the highest certificate that you can get from TCO?
Yes, sir, it is.
And what about additional professional school training?
I graduated from the Harris County Sheriff's Office Academy in 1979. I graduated from the FBI Hazardous Devices School in 1985. I have also graduated from the Bill Blackwood Law Enforcement Management Institute of Texas in 1996. 2011, I was able to go to the FBI National Academy in Quantico, Virginia. And I've also completed the Force Science course that was held in Scottsdale, Arizona.
And what about formal education?
I graduated from high school in South Sioux City, Nebraska. College, Sam Houston State University, Huntsville, in 1980. 1998, I graduated from Sam again with a master's degree. In 2004, I completed my doctoral work in the College of Criminal Justice.
Or were you awarded a PhD?
Yes, sir, I was.
So you are a doctor?
Yes, sir.
Dr. Captain?
In Germany, yes, Dr. Captain.
Military training?
Yes, sir.
Could you tell the judge about that, please?
I was enlisted in the United States Marine Corps in 1985 and honorably discharged in 1979.
And what was your MOS, as we would say in the Army? What did you
Hang on just a second. 1985 happens after 1979, I think. So.
1975.
75, there we go.
Military training. What was your specialty, occupational specialty?
0311 infantry.
And what grade did you leave the military as?
As a corporal.
And did you do any overseas time while you were in the Marine Corps?
We did a brief NATO tour. We entered Germany, took on the Bundeswehr, and beat them pretty handily in a working.
Okay. I employed you and asked you to consider being an expert for us in this case. Is that true?
Yes, sir.
And we agreed to pay you, of course.
Yes, sir.
And I asked you to review certain things so that you could offer a professional opinion here
Yes, sir.
from the jury and from this judge. What all did you, well, let me ask you something. As a captain in the Harris County Sheriff's Department, how big is the command that you're in control of?
I have an authorized strength of just under 200 patrol deputies, sergeants, and lieutenants. And District 1 covers an area of approximately 440,000 people.
Do you have FBI agents that are attached to your command?
Yes, sir. Under a new program where we're linked with the Violent Crimes Unit, I have 2 FBI agents under my command, and my operational command, as well as detective units and units from the Department of Public Safety.
And ATF, do you have guys from there attached to you?
Yes, sir.
Women? So they're all part of a task force that you're one of the commanders over?
Yes, sir.
Now, personally, as well, what did you do? What have you done to work yourself up to being a captain?
Started as a deputy in the jail, and in Texas sheriffs, you work jail work and you work law enforcement. You kind of bounce back and forth between the two. I was one of the founding members of the bomb squad there in Harris County in 1984. I was a patrol lieutenant there in District 1 as well. I've been the task force commander. I developed the SWAT team in, I want to say 2010 and 11. Developed that, merged that with the bomb squad, a little bit of everything.
And as a captain, then, what is your basic function now?
Again, as the district commander, I work with my deputies through my lieutenants and sergeants. I also have quite a few responsibilities in the community. I have been nominated for the board of the Houston Northwest Chamber of Commerce. We work with several churches. We have community functions, things of that nature.
And you've been here in the courtroom and you heard us talk about TCO. I assume that you are a Texas police officer certified by TCO.
Yes, sir.
You were here when Dr. Hayden testified.
Yes, sir.
And you've been here while some of the testimony has been presented. I asked you to review Gross's testimony. We provided that to you through the court reporter.
Yes, sir.
You looked, what else did you look at?
I've looked at everything I can get my hands on. I've looked at the Dallas County Sheriff's Office reports. I've looked at state law. I've looked at the various other statements, things of that nature. I've looked at the videos, specifically the Frederick's report. I've gone through that extensively. There are a number of things in this case that I looked at.
And in preparing to come here and testify, is that the same procedure that you've used in other cases that you've testified in?
Yes, sir.
And have you testified in other trials, other cases?
Yes, sir, I have.
As a use of force expert?
Yes, sir.
You classify yourself as a use of force expert?
Yes, sir, I do.
And did you take into consideration what you and Dr. Hayden obviously learned through Forsyth?
Yes, sir, I did.
Do you think that particular course that you're a graduate of and what Dr. Hayden talked about was beneficial to you in trying to make determinations about your own troops that are under your command when they're involved in use of force issues?
Yes, sir, because one of my duties is to review every use of force that occurs in my district, also every pursuit that occurs in my district. I not only read the reports in each and every case, I also view body cam footage if it's available. I also view dash cam footage if it's available. And again, I use the same methodology there that I'm using here. I get all of the information that's available to me, review it, and then determine whether or not that use of force is justified.
you use the word justified, do you also determine whether or not that use of force is reasonable?
That's critical, yes, sir.
Okay. And you pass that information, I assume, on to command.
Yes, sir.
Did I ask you to form an opinion in this case?
Yes, sir, you did.
And did you, in fact, form an opinion?
Yes, sir, I have.
And did listening to Dr. Hayden and the testimony here in the courtroom and reviewing the grand jury testimony and Officer Gross's testimony, do you think you have adequate information to form an opinion and share it with this jury?
Yes, sir, I do.
Did you prepare some, I guess for lack of a better word, plaques that we would use for the jury to understand your testimony?
Yes, sir, I have.
Do you have those with you here today?
Yes, sir, I do.
Could you get those out for us, please, sir?
Okay, Your Honor, may I step down?
You may, just keep your voice up so Ms. Wood can hear you, and I can too. You can show those so that Mr. Snipes and I can see them. If you can kind of angle yourself, I would appreciate it.
Your Honor, please.
It sounds good to me. Can you see that, Mr. Snipes?
Yes, sir.
All right,
I
keep
think
your
I'll
voice up.
probably for the record, probably have it marked so we can, let's mark that
Tell you what.
court reporter.
Let's mark those, Ms. Wood, if you don't mind.
Yes, sir.
Can you bring all those to Ms. Wood, please?
Yes, Your Honor.
Thank you, Mr. Brissett.
Let me ask you one thing before we talk about those exhibits. Have you been involved personally in use of force issues as an officer?
Yes, sir.
How many times?
I've been involved in 3 shootings.
And in each one of those shootings, did you go through the same scenario that Roy Oliver's going through? Pretty much so. I mean, in the IED investigation, criminal investigation, were they presented to the grand jury?
One of the shootings, my last shooting, was involved, presented to the grand jury. The other 2 shootings, the suspect was never identified.
So you, not only from a professional standpoint, but from a personal standpoint, you've been involved in use of force issues.
Yes, sir, I have.
Okay. Can you pick up your exhibits there and tell us what number is on that one, and then tell us what it is?
This is 17.
Since exhibit number 17, did you create that exhibit yourself?
The artwork, yes, sir, I did.
And it's got OODA loop on it. Can you tell the judge what the OODA loop is?
There was an Air Force fighter pilot, Lieutenant Colonel John Boyd, back in the 50s, and he basically came up with this concept about reaction time. And he made a bet with his squadron mates that I can start in a position of disadvantage and within 40 seconds be in a position of advantage using the OODA loop. And he broke it down in the fact that an individual needs to observe something. Then once they observe it, they have to orientate it as what is that? It's kind of like trying to see a street sign in the fog. Once you use your experience, information, you're analyzing it, you're basically trying to figure out what that is that you're observing. Then you make a decision about that. Once you make your decision, you act on what that decision happens to be. And of course, there's feedback loops all the way around.
So what is OODA loop?
Observe, orient, decide, and act. It's basically the process human beings go through when they're confronted with an issue.
So the OODA loop is actually OODA, and then the loop means that all of that information is in a circle. All right, the next exhibit. That would help the jury understand your testimony.
Yes, sir, I do.
And is that accepted in the course science? Is that what you're taught in course science?
The OODA loop is accepted in the military, it's accepted in law enforcement, it's accepted in tactical law enforcement. It's a very common concept, yes, sir.
Okay. Your next exhibit.
Do you have any objection to Defense 16 for purposes of the hearing? No. All right, so
What
sorry, was that 17?
Yes.
Sorry, Defense 17, thank you.
This is Defense 18.
Did you create that particular exhibit yourself?
Yes, sir, I did.
Can you explain to the judge and Mr. Slice what that is?
What this does is it takes the timeline and breaks it into half-second intervals, and this is the timeline that was used in the Frederick's report.
Where did you get that? Did you go through Frederick's report?
Oh, yes, sir.
Did you find that being beneficial to you in forming your opinion?
Absolutely correct, yes, sir.
Did you feel that Frederick's report was information that anybody doing a reconstruction of a use of force, that kind of information would be important to them?
Not only important but critical, yes, sir.
Go ahead and explain to us. Thank you.
So what I've done is using the shot analysis, I placed Officer Oliver's shots on the timeline. Then what I've done, using the OODA loop and using what I've already been trained in force science, I've gone back to figure out the times when he made those decisions. The green is Officer Oliver's decisions to start shooting. The red is Officer Oliver's decision to stop shooting.
Now, let me stop you there and ask you, why is that critical? I mean, most people think you point at something, you shoot it, and that's the end of it.
No, sir, I'm sorry, Mr. Science proceeded.
What is force science and all the other studies taught people like yourself that are an expert?
That human beings do not react instantly. We take time. It takes time to go through the OODA loop when we're confronted with something. I don't care if it's something as simple as trying to fast forward through a commercial or you're involved in a shooting or something in between. So it takes us time to go through the OODA loop, and what that time does is it separates the decision from the action.
Now, the decision and the action from the information that Frederick's report gave us was how long? Time-wise?
The science tells us it's between a minimum of 1 second and a maximum of beyond a second and a half.
And that would be from the time of you going through that scenario of making that decision to fire the weapon, and then do you have to reverse that whole process to stop firing the weapon?
Yes, sir, you do. In other words, you see an event, you make the decision, I'm required to fire. From that point until the point the shot is actually fired is in a minimum of 1 second, and it can exceed a second and a half.
What did you find in your research to putting together that particular exhibit?
Well, what I found was, and as you can see these cross-hatched areas here, there's a time period when Officer Oliver made the decision to commence fire. There's a time period where he's somewhere in this area when he made the decision to stop firing.
Are you still firing when you make the decision to stop firing?
Yes, sir.
Can you explain what force science and all of these tests and all of these studies have shown, how that works?
Yes, sir. There's actually two processes at work. There's the shooting response, and then there's the stop response. And since the shooting response occurs first, and it's being reinforced, it actually takes longer for the stop response to get through and actually stop the action.
And when we talk about the stop or start to get through, can you explain the eyes, the brain, where it goes to the flexor and shooting finger? Can you go through all that for us, please?
Absolutely. And I'm not a psychologist, I'm not a kinesiologist, I'm not trying to play with
What you've been taught through all of the studies and schools that you've been through.
What we've been taught is that basically you can observe something through any of the five senses. You orientate that as exactly what that may or may not be. This takes time. The brain makes a decision, and the brain orientates. I think this is this, whatever it may be. And then it takes time to actually act, make a decision, what am I going to do? And then you act on it. But that still takes time for that action to go from the brain down through, and in this case, shooting to the trigger finger to actually actuate the trigger. And the downside is that it's kind of like rolling ping pong balls down a pipe. When the start shooting ping pong ball, if you will, is rolled down the pipe, and then a stop shooting ping pong ball is rolled down that same pipe, at the other end of the pipe, the shoot ping pong ball is still going to come out first. The stop ping pong ball is going to come out second.
Is there anything on that particular exhibit that you would like to explain that might be of benefit to the jury?
Basically, what's important is what did Officer Oliver see here? Not here. The important thing, what was the relationship? Because we have three bodies of motion.
Let me stop you there because you're pointing at the exhibit and you say here. Can you give us a little more information?
Yeah, where we're looking in the decision area, the shoot, let's call this, for lack of a better term, the shoot decision area here.
That's the green, two green lines on the left of exhibit number 18.
Yes, sir. Thank you, Your Honor. There's three bodies of motion in this event. Officer Gross, Officer Oliver, and the impounded. They're constantly changing position, and at some point in time, everything came, sometime in here, those bodies were in a certain position relative to each other. That's when he made the decision to shoot, and what's critical is where were each of those three bodies of motion in this area here, not here when the shot was fired. What's important is here.
And when you say not here when the shot is fired, can you point to that exhibit? And if somebody was reading this transcript, would be able to know what you're talking about.
Again, I apologize. The start shooting decision area.
And then point to the red arrows.
This is the stop shooting decision area. And basically, it's in this area, this stop shooting area, which is indicated by two red lines, two vertical red lines, and this cross-hatching. This is the area where Officer Oliver made the decision to stop shooting. So what's important here is, again, the position of these three bodies in motion. Where were they in this area?
And the time frames that you have on the bottom there, is that from Grant's report and from the videos?
Yes, sir, it is.
And what does that exhibit tell us from a conclusion? What does it mean?
Well, what it means is we've got to look at the video and see where those three bodies of motion were in the both decision zones. The shoot decision zone indicated by the green lines, and the red decision zone by the red lines. The stop shooting zone by the red lines. And what's sad is here, what we can see is actually Officer Oliver made the decision to stop shooting before he ever fired his first shot.
And so what do the numbers tell us as far as the time span?
This is the time span between the first and second shot, second and third shot, third and fourth, fourth and fifth.
And what, for us that want to know, what does that mean in the time?
It indicates that this is, what it doesn't indicate is panic fire on the part of Officer Oliver. It indicates that this is rapid, well-aimed fire.
And what is the time frame? I mean, how long did it take him to make that?
0.934 seconds.
Can you clap your hands that fast?
No, sir, I can't.
Have you ever seen anybody be able to clap their hands that fast?
I don't believe so, no, sir.
Then that's what this case is about, that period of time right there.
Yes, sir.
Because you heard Dr. Hayden, and I went through everything from the time he left that party and made their decision to go up the street, what Gross did and what Oliver did. He said everything was done correct up until the point, 0.934 seconds. Is that what you got from his testimony?
Yes, sir, it is.
Your next exhibit.
Did you offer that to it?
You offering defense 18?
Well, I was going to offer them all at the same time, but
I need to see that.
Okay.
I was just going to wait.
Go ahead, is the next one defense 19?
Yes, sir, it is.
Could you put that one up and let us see? Did you, obviously, from the video, did you prepare that exhibit yourself?
Yes, sir, I did.
Do you think that will help the jury understand your testimony?
Yes, sir, I did.
Would you explain to the judge what exhibit number is 19 is?
19. As it's titled, one, these 3 photos are from Officer Gross's body-worn camera, and they were taken out of the Fredericks report. The times here are as indicated in the Fredericks report.
Judge, will we have just a moment, please?
Sure.
I apologize, but we're still talking about this exhibit. Thank you, Judge.
Well, ready for us to continue?
Not quite.
Already good. So ready, Mr. Snipe?
Yes, sir.
Okay, thank you. Okay, your next exhibit there,
Is, again, 19.
explain that thing. Mr. Snipe was looking at your other exhibit, so could you go over those?
And again, these are 3 stills out of the Fredericks report showing 3 different times. And what these represent, and again, this is Officer Gross's body camera.
And those photographs came from where?
The Fredericks report. What they are is it sets the positions of Officer Gross and the Impala at the time Officer Oliver made the decision to fire.
And what does that exhibit tell the jury?
Remember on the last exhibit there, I said there's a minimum time, there's a maximum time. Minimum time is a second. This is the headlight of the Impala.
Why did you say this? You're going to have...
There's a white blur on the top photo. There's a,
Excuse me, there are 3 photographs on that exhibit.
yes, sir,
And you're pointing to the top photograph.
top photo.
All right.
There's a white blur about in the middle of the middle lower of the top pair of the top photo. That white blur is the headlight of the Impala. Now, Mr. Fredericks has indicated front passenger side wheel on that very same top photo. And Mr. Fredericks has drawn a red line from that notation down to a point here. It's very difficult to see on the top photo. But what this shows is at the minimum time, 1 second, it would have taken Officer Oliver to go through the OODA loop, that the Impala was to Officer Gross's left. It had not passed him.
What's the significance of that?
The significance of this is this vehicle at the point in time, at the minimum point in time, Officer Oliver made the decision to fire. This vehicle was very well a threat to Officer Gross. It had not passed him.
Go ahead and explain the other 2.
Very same thing here. Again, this white blur in the middle photograph number 2. This white blur is also the headlight. Same notation from Mr. Fredericks. But now this is at the 1 1/3 second.
You're talking about which frame in there?
Again, the middle photograph. So as we can see here, the Impala is a little further back, a little further to the left of Officer Gross when Officer Oliver made the decision to fire. And this is at roughly 1.5 seconds. So what my testimony would be is that Impala was somewhere here, between here at the nearest, here at the furthest, or possibly a little more, but somewhere in this area when Officer Oliver, number 1, made the decision to shoot. Number 2, the fact that the vehicle was to Officer Gross's left and a threat to him. The vehicle had not passed Officer Gross when Officer Oliver made the decision to shoot.
Now, refresh my memory, when Dr. Hayden testified, I don't think he spoke in terms of who. Do you remember that?
No, sir, he didn't.
Okay. All right, what's your next exhibit?
Next exhibit is defense 20. Very same setup here.
Did you prepare that exhibit yourself?
Yes, sir, I did.
And you got that information from where?
The Frederick's report.
All right, go ahead.
Same idea here, except for switching from Officer Gross's body-worn camera to Officer Oliver's body-worn camera. And it's the same
Let me
idea.
ask you, I think you told us that the other one was from Officer Oliver's.
No, this is Officer Gross's body-worn camera.
Well, I think you said Oliver.
Defense 19 uses Officer Gross's body-worn camera. Defense 20, all three photos, top to bottom, are Officer Oliver's body-worn camera. This shows, again, the same idea. Where was the Impala in relationship to Officer Oliver in Defense 20 when he made the decision to stop firing his weapon? And as we can see, Mr. Fredericks has indicated on the note, let's take the top picture, front passenger side wheel. So when Officer Oliver made the decision to stop firing, the vehicle had not passed him. And that's at the minimum time of 1 second. If we push that back to 1.33 seconds, about second and third, the vehicle, and again, this little white blur right here is the Impala's headlight. It's in about the middle of the photo vertically and to the left horizontally. Or the same thing here in the third photograph, and this is a second and a half. This is where Officer Oliver made the decision to stop shooting, and the Impala had not passed him.
And it's a phenomenon that I think all of us sometimes have a hard time to grasp, but when you say he makes the decision to stop shooting, does he stop shooting when he makes the decision? Can your body do it that quickly?
Not humanly possible, no, sir.
So what do the studies show you the normal, for lack of a better word, lag time between the decision to stop shooting and you actually do stop pulling the trigger?
It takes about a quarter of a second to go through the observe stage. It takes anywhere from a third of a second, a quarter to a third of a second to orientate, about a half a second to decide, and then a second to act. And the problem of it is, as a decision gets more complex,
And you were just looking at the exhibit. Which one exhibit?
I'm sorry, so Defense 17. Yes, Defense 17. As the decision gets more complex, it actually pushes that time further out.
I think you can sit down. Or do you have another exhibit?
I do. It's basically a schematic of the salient points of Granby County.
Did you prepare that yourself?
Yes, sir.
Did you take that from the cases?
Yes, sir.
Well, Judge, we would offer defense exhibits
17 through 21.
Yeah, 17 through 21. That's been marked as defense exhibits 17 through 21.
We object to 21, Your Honor. Law in the charge will confuse the jury. That case has been amended several times since it was written, and most importantly, it's not the law of the state of Texas. Otherwise, we don't object.
Well, we offered it because that was what Dr. Hayden based all of his testimony on.
The objections, 17 through 21 are admitted for purposes of this hearing. I'm going to sustain the objection to Defense Exhibit 21. You may proceed. You may proceed.
Okay, thanks, sir. Well, Dr. Captain Coons, do you feel like you had all of the information that you needed to form an opinion as to whether or not what Roy Oliver did that night was reasonable?
Yes, sir, I do.
Do you have an opinion as to whether or not his actions that night in this unfortunate, tragic shooting was reasonable?
Yes, sir, I do.
What is that opinion?
Officer Oliver's actions on the night in question were reasonable.
Mr. Snipes?
You relied on the Grant Fredericks report, is that right, sir?
Yes, sir, I did.
So is that-
Along with a number of other things, yes, sir.
Is that report accurate?
The portion, well, I'll leave that to Mr. Fredericks. That's his report. I'm using information from his report.
But you relied on the report, so you must have thought the report was accurate, correct?
I believe, again, sir, I relied on the information in his report. I can't testify to its accuracy.
But you used part of it in developing your posters here.
Yes, sir, I did.
Okay, so you must have thought that part was accurate.
Again, sir, I
Yes or
acted.
no?
It's not a yes or no question, sir.
Your chart here in 18 indicates that the defendant had decided that he was going to shoot 1 full second before he actually shot, is that right?
At a minimum, excuse me, at a minimum, yes, sir.
Okay. And you know that the glass was broken 0.358 seconds before the first shot, right?
Yes, sir, that's correct.
So the decision to shoot was made before Officer Groves had even got to that car, is that right?
The decision to shoot was made between a minimum of 1 second and 1.5 seconds prior to the shot being fired.
Can you answer the question?
I just did, yes, sir.
No, you didn't. The decision to shoot was made before he even broke out the window of the car, correct?
Yes, sir, that's correct.
That's all I have.
Very good. This witness will be accepted by the court as an expert witness to testify, with the exception of defense exhibit 21. 17, 18, 19, and 20 will be admitted for all purposes. Is there anything else we need to take up before we call the jurors?
Just demonstrative.
As demonstrative, yes, sir.
Maybe 5 minutes. This is actually
Sure. Before we call the jury, I'll let you kind of get ready to go, but I'm asking, I guess, is there any other experts?
No,
that we have?
sorry. No more experts.
Is there any other matters? So in other words, 5 minutes from now, I'm going to call the jury, then we can start. Will you all be doing it over the stage? Will you, Mr. Lee?
We have 10 minutes, my ball is accurate.
Sure.
One quick matter, Judge, regarding the house thinking on the exhibits.
Hang on just a second. It's like the big, thank you. Fading everybody out. Please have a seat.
Sorry.
It's okay.
During the 702 hearing, I believe Ms. Francis stated, admitted, or offered in the evidence statement number 248, which was her second firearms report after the DPD 9 leads. It's my understanding that there was confusion. The two pieces of evidence were offered under that same exhibit number. 248 actually ended up being her first firearms report, which is in the evidence right now for all purposes. And the court allowed us at that time during the hearing to withdraw that particular exhibit.
So actually, you all requested and Mr. Gill asked that it not be withdrawn, so we have, my understanding, 2 exhibits that are exactly the same with different stickers on it.
So in that vein, we would just like to offer that particular report as states number 286.
26?
286. For record purposes. Just so there's no confusion with regard to two exhibit numbers for different exhibits.
I think it's too late for the no confusion part. Mr. Gill, you have objections for record purposes?
240, the actual documents he's talking about, I think, if you look at them one to one, they have different items on both of them.
All right, I tell you what,
We'll get it done at the break, Judge.
get it done on the break. Please get with Ms. Wood. Y'all work that out. It's her record. Is there anything else?
There you are.
All right, we'll come back at 9:45. The jurors are walking in. Court is. Thank you, Sheriff. Y'all may be seated. Members of the jury, we will call the state's case in chief. Mr. Snipes, what says the state? Very good. Members of the jury, it's customary in our law and our procedure to take a very brief recess at this time. So if you would, please go with the sheriff. All rise for the jury. Sheriff, don't take it very far.
Yes, sir.
Y'all may be seated. Mr. Gill, we're outside the presence of the jurors. You indicated to the court that you wish to make a motion. Go ahead.
Yes, Your Honor. And first of all, you've taken up a motion for instructed verdict earlier, and I would re-urge that at this time.
All right, your motion for an instructed verdict on all three of these indictments is denied.
Thank you, Your Honor. Also, yesterday, we heard some testimony through a couple of expert witnesses that were sponsored excuse me, by the state of Texas. We heard some testimony about a range of fire analysis that was conducted based on the examination of some hair that was represented, came from autopsy. We objected at that time that there was not a chain of custody that had been shown for the hair that was being testified to. That's never been shown. The hair was never introduced in front of this jury. The testimony was conditionally admitted, subject to the condition being met by the state of Texas. If they never met the condition, we would ask that all of that testimony be stricken.
Your request to strike the testimony that you referred to is denied.
Yesterday, there was also testimony from a gunshot residue expert sponsored by the state of Texas that she did analysis based on some gunpowder evidence that was collected through the use of SEM stubs by the Dallas County Medical Examiner's Office, and the testimony regarding those was conditionally admitted, subject to the condition being met by the state of Texas through the introduction to the medical examiner of the SEM stubs. That was never done. No SEM stub was ever admitted, and no chain of custody was ever shown on that testimony, and therefore the condition was never met. We ask that that testimony be stricken.
Your request for the testimony to be stricken that you described is denied.
The first day of trial, we were given some materials from Mr. Snipes that the state of Texas representative obtained via search warrant. The state represented to us at that time that they were not going to use the material. It was purported to be from a Facebook page. We received hints since then that the state of Texas may, in fact, attempt to use that information during our case, and we would ask that if the state of Texas intends to go into any evidence that they claim to have derived from a social media page or intend to question any witness regarding social media information that was purported to have come from Mr. Oliver, that they first approach the bench without going into it or without alluding to it, and so that we can obtain a ruling from the court whether or not that matter is admissible.
And Mr. Sykes?
Nobody broke the bench, Judge.
Okay, your motion limit is granted.
That's all we have.
All right, thank you.
Judge,
Mr. Bissett?
Judge, in continuation of the 3914 discovery obligations the state has, if this matter from social media was obtained with a search warrant, we'd ask for a copy of the warrant and the return, because we don't have it. We were provided a disc, but no warrant, no return.
Okay. Will you provide that?
Yes.
All right. Is there anything else from the defense or from the state? All right. Go ahead, Sheriff.